Hello everyone. I, Forum Patel from LG School of Law, would like to extend my warm welcome to every viewer. Welcome you all to the sixth session of the copyright laws under the intellectual property rights. Now friends, in the previous 5 sessions, we discussed about the concept of the copyright, of course the history along with the meaning, the different kinds of the rights and other concepts. Now, we had to answer that query which was posed in the previous session. That is what happens when somebody infringes or rather somebody takes away the ownership of the copyright laws or somebody is not giving due credit or not by following the legal due processes. Now, that means we have to start with the chapter of the infringement. The copyright infringement, my friends, is very well known. Reason being that if any of the rights are violated, you have to have the remedy for the same thing. In dealing with the copyright, we must bear certain things in the mind that copyright does not protect novelty but only originality is protected. It protects the expression and not the idea. Therefore, if it is the only method of expressing the work, it cannot be protected. Best example would be the telephone directory where with the names, address, phone numbers are given and also in the alphabetical order. Now, there can be no other way of expressing the same. Therefore, this would not amount to copyright infringement. This is popularly referred to as an idea expression dichotomy, my friends. That means that would not be infringement of the copyright. So, that would pose another query. Then what are the key factors to initiate any infringement? The proof of the ownership of the copyright, infringing substantially similarity in that infringements by the infringer has to be proved. Once the rights of the owners has been established, the next step is to prove that there is an actual infringement taken place. If the defendant makes copies of the copyrighted work and commercially exploits such copies or blatant infringement, nothing further needs to be proved to establish the infringement apart from what has been discussed above. Now, however, more complications or more questions that may have arisen in the concept of the infringement. The plaintiff, in such cases, in order to prove the infringement, has to show certain aspects or certain points that the defendant copied the work directly from the plaintiff's work or from some owner's work. The elements that were copied were all together. It amounts to improper or appropriation. That means it has to be an exact copy or somewhat so similar that mere distinction is not possible, and directly copying from the work of the original creator has been done. Now, realizing that the direct evidence of the copy will be rarely available, my friends, people around the world, they are not so foolish to copy your own work. What they will do is they will diversify or they will put it in any other way on the basis of the circumstances or any other possibilities. So for that, the court needs to have the basis of the circumstantial evidences, specifically through the interference from the excess point of view, that how far the work was accessed or accessible by the infringer, that drew the similarity between those two works. Now, in the case of the Super Cassettes Industry versus Nodules Company Limited, the defendant played cassettes in hotel amount to copyright infringement. This was clearly held to be the act of the infringement of author's right over the copyright. Copying can therefore be proven by inferences. It can be inferred that the defendant had in fact copied the work from that person was accessible to the other person's work and the due similarities are there between both the works. That would prove the infringement point so far. In another case of Roma Mitra versus State of Bihar, my friends, the plaintiff who was a student, he gave work to the guide. Now the guide published the work as her own. The published article was substantially similar and therefore it amounted to the copyright infringement. The person even cannot do the same thing because of the publication part. When you are publishing certain things, then that is not merely for the purpose of the teaching. Exception to this rule would be the teaching, my friends, because teaching is an exception because you are trying to prove your point. For that you have to draw certain attentions, you have to take certain interference from certain other people's work. That won't be infringement of the copyright. But when you are taking the work and publishing it as your own original work, that would amount to copyright infringement, my friends. I would be putting certain references once the whole slide or once the whole sessions are over. That means that I am giving due credit for my lectures or for my sessions to the people or to the contributor to the websites who has provided me with the due reference materials. Then it will not amount to the copyright infringement. But if I am not doing so, then, and if I am showing that this work is originally mine, then that would amount to the copyright infringement. The same was the case in the Roma Mitra versus State of Bihar, as we stated. In the case of Thai Ink versus GMA Accessories also, it was held that similarity between works is highly unlikely to have been an accident of independent creation. This is an evidence of the excess. That means two people at the same time cannot have exactly same similarity or accident in that case, so that the works become very similar in nature. That will not be considered as an exception to the infringement. Therefore, it is a reciprocal relationship between the proof of the excess and the similarity. This relationship is subject to two important limitations. Now, what are these limitations, my friend? In S.K. Dutt versus Law Book Company, the court determined the amount of the substantiality which should be more than half of the total work. It has also held that where the half of the work is copied and the remaining being the original, it does not constitute infringement. This means this is one of the rules of the exceptions. If there is no similarities, no amount of evidence of excess will suffice to prove the copying. And if the evidence of the excess is absent, the similarities must be so striking as to the preclude of the possibility that plaintiff and the defendant arrived at the same result. Therefore, to summarize the conditions to prove the point of the infringement, we can state that closely similarity has to be there. This similarity which is to be taken needs to be unlawful, that is without due permission. Some connection has to be proven. Access to the original work has to be there. These are the tests which we need to apply before proceeding further with the copyright infringement. Now, my friends, the following are certain commonly known acts involving the copyright infringement, as you can see on the screen. Making the copies for the sale or hire of selling, permitting any other place for the performance of the work, then distribution of the infringing copies for the purpose of trade or any such which is extend to affect the prejudicially of the interest of the originator or the owner, then public exhibition of the infringing copies by the way of the trade, and importations of the infringement copies into our country. These are the cases which are commonly known as the common act, which will be considered as the infringement of the copyright. A copyright owner can take legal actions against the person who infringes the copyright in the work. The copyright owner is entitled to get the remedies by the way of the injunction, damages, and the accounts. The district court concerned has the jurisdiction in the civil suit regarding the copyright infringement, where in the case of a literary, dramatic, musical or artistic work, a name purporting to be that of the author or the publisher appears on the copies of the work as published, or in the case of the artistic work, appeared on the work where it was made, the person whose name so appeared shall, in any proceeding in respect of the copyright in such work, be presumed unless in contrary is proven to become the original author. That means we need to have certain tests to be applied. Now, the first test that can be drawn as the protected expression test. This first test for improper appropriation is to identify whether the defendant's work copied any other protected work from the original creators. That is, If it is exclude if it exclude those elements from the plaintiff's work which are not protectable under the law, then that would be the test which the court needs to apply, or the court needs to have before deciding the whole doctrine of the scene affair. This doctrine is applicable when the infringement needs to be decided, which is there specially for the idea expression concept which we talked. In Nicholas versus Universal Pictures Corporation, the judges had held that when the plagiarism does not take out the block in situ but an abstract of the whole decision is more troublesome. Upon any work, and especially upon a play, a great number of the patterns of the increasing generality will fit equally very well, as more and more of the incidence is left out. Now the last may perhaps be more than the most general statement of what the play is all about, and at the same time it might consist of the titles, but at the same point in this series of abstractions where they are no longer protected, since otherwise the playwright could prevent the use of his ideas, to which apart from their expression his property is never extended. Therefore, if the idea can be expressed only in a particular method, it cannot be protected under this law. That is, as we discussed the telephonic directories example, that would be the extensive and rightful example for the same test. In the case of 20th Century Fox Interstate Limited versus ZTV Limited, the plaintiff and the defendant were in the same kind of the business, that is of course the TV shows, which was copied by the defendant. The court held that it does not amount to infringement as it comes under the idea expression dichotomy and there is no other way of expressing that idea. It was also held that mere outline of copyright is not copyrightable except being distinct in nature. There was very important and interesting case which is famously known as the Rameshwari photocopy case or Delhi photocopy case. The citation is the University of Oxford and others versus Rameshwari Photocopy Services and University of Delhi in the year 2012, wherein the Delhi University complied that the requirement portion from the books of the Oxford, Cambridge and Tyler and Francis and distributed it to the students. Infringement suit was filed by the publishers, Oxford University Press, Cambridge University Press and the Tyler and Francis. This issue here is that the university copied the copyrighted work and thereby they infringed. But on the other hand, it was issued to the students, which is of course for the academic purpose, which is the exception, which comes under the fair dealing, but for a consideration, which is not acceptable under the fair use. It was for the academic purpose but not as per the fair use. Now the case is before the court and it is yet to be decided of course. The next test which has to be applied with the idea expression is the audience test. To establish infringement, the plaintiff should demonstrate that any audience would find the expression in the defendant works substantially similar to that of the other person or the creator's work. The court sometimes refers to this as an audience test or ordinary observer test. The principle of the test is from the perspective of a third person or rather a layman. The two works should be there simultaneously, and if the third party can be able or they are able to make a difference, distinguishing difference between both the work, the similarities is not there, then the test is applied correctly. The next is contributory infringement, is where the copyrighted work is duplicated by another person without the consent of the existing lawful excuse, of course. That means you are not taking the due permission which you have to take as per the law. For an example, if a person has a 500 rupee note and it takes a color Xerox in a shop, the person is infringing the Xerox shop, and the person of the Xerox shop is also an abettor, as it is giving the contribution in the infringement process. There was a very famous case of the Sony Corporation versus of America versus Universal City Studio. The Supreme Court of the United States in this case, which rules that the making of individual copies of the complete television shows for the purpose of the time shifting does not constitute copyright infringement, though the lower courts considered it to be the contributory infringement, but for the fair use, of course. That means, my friends, that the act, or rather copying by any other person, does not always amount to infringement. Some examples of this act which does not constitute infringement under the Copyright Act can be stated as follow. The first is fair dealing, then adoption of the computer program, fair dealing with the criticism, personal use, then teaching purposes, etc. Then judicial proceedings, then exclusive work of the House of the Legislations, non-corporations, which are the matter for the institution purposes, question papers, of course with consent, that is legal due process which is being followed, and non-paying audiences. If these are the things, or rather there are other certain exceptions also, which is like research for the private study, if it is there, if the person has made less than 3 copies, if it is available in the official gazette, that means if it is there in the public use, if the report of the committee or the commission is there, or after the expiration of the copyright term has been there, then my friends, the act cannot be considered as an infringement under the copyright laws. Now, when we are talking about the whole infringement and its exceptions, we must understand that what are the punishments that are available when we are talking about the infringement. The minimum punishment for the infringement of the copyright is imprisonment for 6 months with the minimum fine of 50,000 rupees. In the case of the second and subsequent conviction, the minimum punishment is imprisonment for 1 year and fine of 1 lakh rupees. This means, my friends, that the whole protection of the copyright under our Indian law has been provided along with the punishment part. The person needs to prove that the fair usage was not there, or rather any exceptions to the infringement was not there in the process, and so as the infringement act has taken place. So friends, this was all about the whole concept of the copyright along with its history, the due concept, the rights which are available, who can become the author, the importance of originality when we are talking about the copyright, and of course the violation of the rights which will amount to infringement. Now friends, as you can see on the screen, I am not infringing any of the rights under the copyright laws. So these are the references which I have used to create the whole sessions, and you also can take a look for the detailed studies. So friends, till the next session comes out, I would like to thank you all for listening to the sessions very carefully and patiently. So till the next subject, you guys stay tuned and keep learning. Thank you so much.